Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hello and welcome to the Virtual Spring Meeting. My name is John Roberti, and today we have another great panel. It is, where do vertically integrated digital platforms end? And the panel is sponsored by the Corporate Counseling Committee, the Federal Civil Enforcement Committee, and the Unilateral Conduct Committee. With me today are two experts who are going to help to put the panel into a little bit of context. First, we have Eli Katz. Eli is a partner at Cahill, Gordon, and Rindell. Eli, hello.
Hi, John.
Eli is also a co-chair of the Corporate Counsel Committee. With us today as well is Matthew Kent. Matthew is a partner at Alston & Bird, and he is also the co-chair of the Unilateral Conduct Committee. Hi, Matthew.
Hi, John. Thanks for inviting me.
All right, Eli, let's start with you. What is today's panel about?
So today's panel is going to explore digital platforms as they evolve and expand, and also their relationships with other firms. This is a topic that we're all very excited about. More specifically, they're going to be talking, as I understand it, about how has antitrust or competition law viewed vertical conduct, vertical mergers, vertical conduct, and how should the agencies view these vertical relationships going forward.
Great. Matthew, why is this topic important?
Well, John, as Eli said, this is sort of at the forefront of everybody's mind right now, and I think it is both timely and it's complicated. And so when you put those two things together, it makes a perfect program for folks to hear from the experts about. When we think about digital platforms and we think about the EU, we see a lot of enforcement, we see investigations on conduct. We think about the vertical merger guidelines, the draft that has been put out by the FTC and DOJ. And so all of those things obviously make it top of mind for both our clients and for practitioners in the space. But it's also one area that's pretty complicated because we're talking about a number of regulatory regimes and other legal theories like privacy, intellectual property that are also impacted. And we also are questioning whether we have the right economic tools to evaluate vertical integration with digital platforms.
Matthew, thank you. Eli, back to you. What do you hope to get out of today's panel?
So today I'm hoping a few things. First of all, I'm just looking forward to this panel because it's a topic you hear a lot of talk about. There's talk about digital platforms, vertical issues. What I'm hoping to hear here is from people who really know about it, who've thought about it deeply, and who've worked on these issues in real cases. So I'm looking forward to a thoughtful, informed discussion about these topics.
All right, Eli, Matthew, will you stick around? Let's watch the panel together. And then at the end, we can come back and maybe you all can share some of your takeaways. Would that be okay?
Sure, yeah, I'd be very happy to.
Great.
Absolutely.
Okay. Wonderful. Okay, let's send it down to Gabrielle KOHLMEIER, who is the moderator of today's panel. Gabrielle, the floor is yours.
Thanks, John. Welcome, everyone, to our panel on where do vertically integrated platforms end. This topic was timely when it was conceived, with jurisdictions around the world doing not only merger reviews involving vertically integrated platforms, but also conducting investigations into the conduct of vertically integrated digital platforms. Now, in light of the global pandemic and the role that vertically integrated digital platforms are playing to connect, entertain, track, compete, and more, the topic is more relevant than ever. So I'm delighted that the virtual spring meeting is taking place. And even though we can't bring them together physically, we're using the power of digital platforms to bring together this esteemed brain trust, including FTC Commissioner Noah Phillips, Thomas KRAMLER, head of unit at DG Comp, Cristina CAFFARRA, head of the European competition practice at Charles River Associates, and Craig Waldman, partner at Jones Day. So, Cristina, as we were preparing for this panel, You were saying that this is the sexy topic for economists right now. So let's start there. What makes this such a timely and hot topic?
Thank you. Let me start by saying that it is a pleasure to be here, of course, particularly with this group of panelists. It's a shame, of course, that we cannot be in person at ABA, but I'm delighted to be here and take part in this big discussion. So why is it an exciting time for economists in this space? I think there is effectively a confluence of factors. When you think about the way we see vertical integration generally, we certainly, the way we view it has changed pretty dramatically in recent times. And that has been compounded by very much the focus on tech, the specificities of tech. So a combination of the view that we've been perhaps too permissive in this vertical space and the increased focus on tech has very much coalesced into a view that we've gone straight from, oh, we kind of know what we're doing in vertical. We understand that integration is positive. The standard economic view is that these kind of things are beneficial. They're rarely anti-competitive. Foreclosure is exceptional. You really have some powerful intuition about one monopoly profit to, oh, well, perhaps we've been a little too permissive over here, all the way to, gosh, we really are totally missing out, umpire and player. We need to just review what we are doing. We cannot allow integration to run amok. We cannot allow these platforms to be simultaneously players on their own assets and host of third parties. So really the view is shifted considerably. I have personally significant sympathy for the view that one wants to dial up enforcement in this space, but at the same time, I think that there is no economic underpinning for this most extreme recent narrative that essentially says we really cannot have a platform being simultaneously players on these assets as well as hosts. I think this break them up, umpire and player type of view is not one that I recognize, and it is one that economists, I think, broadly do not recognize. There is an overwhelming narrative out there that very much says we cannot allow this inherently and by nature. If you allow a platform to play and offer its own services on its own asset in competition with third parties, bad stuff will happen. It will have bad incentives to behave as a bad actor. And I think this is overstated. We cannot have these blanket presumptions, not least because in and of itself, these vertical issues aren't entirely new. We've encountered them in other environments. We've spent time in telco broadcasting in over the decades, thinking about the specific circumstances in which a player on a platform has incentives to foreclose third parties that also operate on that platform. And we have some empirical work, we have some theory, we know pretty much what to think of that. Now, it isn't as if all of that suddenly ceases to exist because we're talking digital platform. That kind of fundamental economic work is still relevant. What needs to be done, and this is really where we are, is translate that economic work that we used to underpin some of our insights into the kind of digital environment. And this is the work that is exciting, that is happening now, that economists are getting their teeth into, which is in some sense overdue. We are adapting our insights to take into account the features of digital that we know well: double-sidedness, network economies, indirect network effects, data, economies of scope. So all of that is being taken in, and it is making this into a significantly exciting discipline, because competition on the platform, you'd be surprised, is not an area in which there is much relevant economics which is specific to the characteristics of digital. Again, this is something that, given the attention it has had in the policy debate, you'd think would have had more attention, but the incentive of economists, the focus of economists, academic economists are driven by other things. The policy questions are not percolating directly through. Only now this is beginning to happen, and I can see some exciting work. So just to give you a quick example for the kind of things I can see happening. Think about self-preferencing. It is a classic issue that we are preoccupied with when we talk about these platforms. Indeed, it has been at the foundation of the shopping case in the European analysis. And there is a tendency to just kind of assume that all platforms indiscriminately have exactly the same inherent incentive to self-preference. But what you need to really take on board is differences in business models that drive incentives. And then one needs to recognize, and economists are beginning to recognize, that when you're talking about different business models, then the incentive to self-preference will take different shape, may not be there in the same way. So you have an ad-funded platform, and you have a platform that is funded, for example, through commission, or is it funded through, for example, the sale of the device in large measure? All of these monetization sort of models have different properties and mean different things for the incentive of the platform to hurt, undermine the third party that operates on it. So we need this work to be done to translate economic models into models that can capture these business realities, that integrate the features of digital, and then we will be able to answer this question in a more subtle way. And as I say, I see this happening right now. I see a number of academic economists beginning to get their teeth into this. It is deserving work that's not been done so far. As I said, the incentive of academia somehow unfathomable sometimes to external parties, but this is absolutely what we need, because we cannot rely on blanket presumptions. We need to be given insight and empirical work to follow. And we can talk about that further. But I think that is why I see a number of activities, a number of researchers doing work on this specific theme, and I think that would be worthwhile.
It certainly sounds like there's a lot to do and exciting things. Commissioner Phillips, you are the sole U.S. enforcer on our panel, and Cristina suggests that the hot topic here is really conduct, but in the US, we also had the draft vertical merger guidelines released earlier this year. So what are your thoughts from a US agency perspective? Are the agencies more focused on vertical mergers than on conduct? What is the hot topic from your perspective?
Well, Gabrielle, thanks again for having me on the panel. It's really great to be here, at least virtually, with everybody. Obviously, our thoughts and prayers go out to everyone who's suffering under this pandemic, health and economic, but it's wonderful that through the use of technology, we can gather in the way that we are. You said as the one U.S. enforcer on the panel, and that also makes me think of the fact that I should probably caveat everything I say with the notion that I'm just speaking as one enforcer, and my views don't necessarily represent those of my colleagues or the Justice Department or the FTC as an institution. To answer your question, I think both mergers and conduct are things that we're looking at and continue to look at very carefully. I think there is a tremendous amount of wisdom to everything that Cristina always says, but certainly in terms of what she just said, the notion that you're dealing with a variety of different business models, and you're going to want to look in the particulars of a given case at what the incentives are and how those incentives in fact play out if you're considering enforcement. So if you're worried about foreclosure, let's say, or raising rivals' costs, your incentive to do that, your ability to do that is going to depend on a lot of factors that maybe abstract theory doesn't really give you a lot of guidance into. It may tell you where to look or for what to look. But at the end of the day, especially when it comes to enforcement, facts are going to determine as much as anything. Look, we are looking very carefully at vertical mergers. There have been a number of cases where vertical theories have been explored and where even we've gotten consents to address concerns about vertical issues. Staples is one, Fresenius is another. But no, I don't think that vertical mergers are predominating as an area of concern relative to conduct and the sometimes vertical issues that conduct can present. I mean, in terms of conduct cases, we've brought, in my tenure, which by the time this comes out will be almost to the day 2 years, we've brought 3 Section 2 cases the SureScripts case, the Illumina case, and the Viera case involving Daraprim. Those are all in the healthcare space. That's an area where we see a lot of concern, and a lot of the discussion in the public sphere on the newspaper editorial pages in the last few years has been focused on tech. But certainly we can see vertical issues relative to conduct, relative to mergers in any space, and we're always going to be looking out for those. And as Cristina noted, we've obviously got out for comment the vertical merger guidelines. There's not a lot I can say about that publicly because it's out for comment, or because we're considering the comments that have come in. But certainly vertical issues, whether they start in a merger context or whether they arise more organically in the context of a conduct case, remain important issues at which we're looking.
Great. So, Thomas, the European Commission has been very active, and some say ahead of the US, in examining what changes may be needed to competition, including with respect to vertically integrated platforms. Can you set the scene for our non-European audience members on how vertical issues are viewed and assessed on your side of the pond, and how that might be changing?
Yes, thank you. Greetings from Brussels, first of all. Happy to join this panel. I have to say I find it a bit awkward to talk about antitrust enforcement in these times of worldwide pandemic. I think it's not the first thing on people's minds nowadays. It might have more role to play, I guess, in the second phase when we come to recovery. If you go back to the 80s, you had IBM, a vertically integrated platform that integrated hardware and software capabilities, and antitrust action was taken against IBM. In the 90s, you had Microsoft, a vertically integrated platform, if you want, that integrated PC and server capabilities. In Europe, a case was run against Microsoft for prohibiting interoperability between the two systems. So these issues have been with us for quite some time. And the theories of harm that were actually elaborated in these cases, they're quite relevant still today, I think. Think about tying, exclusivity arrangements, denial of interoperability information, which could be seen as a self-preferencing case if you want. So if you take the Microsoft case, could very well be. But what is different today is, I think, the size of the issue. The platformization of the economy has possibly created more gatekeeper platforms than we have ever seen before. And that's why one has to raise the question whether the issues have become more systemic in today's world than they have been in the 80s or in the 90s, when we also had vertically integrated tech platforms. So what's the approach here in Europe? As Commissioner Phillips rightly said, facts matter in these cases. So there's consequent enforcement on our side, especially in unilateral conduct cases and the Google cases that the Commission has finished and launched. Basically, be a witness thereof. Google Shopping is a nice is probably not the right word, is a good example for a vertically integrated platform that on the one hand has the search service, and on the other hand, Google has a shopping service. And what we found is that Google favored its own shopping service over the services of rivals. So a typical dual role platform case, if you want, where you can see that the incentives to basically favor your own product are particularly high. And we have other cases in the pipeline which will have to deal with the same issues, such as the investigation we're running into Amazon. So what we're doing in terms of enforcement, we're also looking into how the current law can be used to improve our enforcement capabilities, and that particularly we're looking into remedies, whether we've done enough in terms of remedies, for instance, whether we should move away or be a bit more bold when it comes to ordering a company to do certain things and not just have cease and desist orders, whether we can go as far as having restorative remedies. There's a big debate about that in the European Union. And then we have revived the tool of interim measures in order to be quicker in our enforcement. We recently introduced interim measures in a case against Broadcom, which is now appealed. So we're trying to speed up enforcement to make remedies better tailored in order to enforce more appropriately in platform markets, especially also with respect to the dual role of vertically integrated platforms. There's also a reflection process going on in Europe about ex ante regulation, and there are many ideas pondered nowadays. There is a proposal for changes in the law in Germany, which basically declares some companies, or would declare some companies as companies of paramount importance on which specific forms that have a dual role. There are some ideas from the Benelux countries of a telco-style regulation, which would apply to certain dominant platforms. As I said, there are many ideas. None of this is yet fully implemented. The Commission will consult on proposals. Certain risks. We'll have to see where this road leads us. As I said, the discussion is ongoing, and no firm decisions have yet been taken. But there is, I think, political will on the European side, at least, to properly consider complementary ex ante regulation, which would complement current antitrust enforcement.
Great.
Better?
Thank you, Thomas. So there's clearly a lot going on, a lot of thinking and proposals, ex ante and enforcement related. But Craig, can you bring this to an immediate and practical level? How does all of this affect how you would counsel vertically integrated platforms or those dealing with them, both in terms of conduct and mergers?
Yeah, I'm happy to, and like the others, I'm pleased to be here. Yeah, I mean, obviously this is tricky. You heard three very important voices from the economic side, the EU and the US. They all said exactly what I would say, which is the facts are sticky, stubborn things that matter. So I think when a company comes to us and asks us whether they have an issue, you got to start with, my view is you can't treat all these companies and all these platforms and all these entities the same. I would even argue that many of them aren't even platforms. And you got to start from the basic idea whether there shouldn't be that many companies that have these kinds of issues, because there's a gating question as to whether someone has the dominance or the market power that ought to cause these sort of questions in the first place. But you know, in some ways, Gabrielle, I think we will know more, I would say in the US at least, in the next year than we know now, not because necessarily the case law precedent is going to change dramatically, because things take time, but we do know that the agencies have matters in front of them, and they'll be making decisions on what areas of conduct they find to be objectionable, what efficiency justifications they find compelling. And so for the moment, the advice to companies is you got to break apart every one of these questions into the puzzle that it is, figure out if there's really a market power claim that could be made against you, figure out just how strong your efficiency claims are in the conduct that you're doing. And I fear, at least on the US side, and obviously we're watching other parts of the world as well, the place that we're spending a lot of time looking at is what is exactly the kind of conduct that's going to be at issue. I tend to believe, my own view, is that privacy is a perfectly fine doctrine, but privacy is privacy and antitrust is antitrust. And we're getting into some situations where those are bleeding together. And I think my view is they ought to be separate doctrines. So things like that are not decided today. They're challenging today. They're interesting today. I think we'll know more, at least in the US over time here in the near future, when some of these matters are coming to a head, at least about which of the positions the agencies are going to take and how they're going to come out. On the vertical merger guidelines, for what it's worth, I commend the agencies for making them, working together and getting them out. I think we all in the bar recognize that they were long overdue, and I also commend the workshops and some of the open forum that we've been doing, one of which I was lucky to be a part of. My view is they're a great start. I would advocate for more clarity in terms of simple things like, I mean, it sounds silly, but the examples that the agencies provide of when something might be actually a problem from a market harm perspective and when not, to give a little bit more meat to the parties when they pick up the document. A guideline is never going to answer every question. It's not the tax code. I think they could guide more fully in certain respects. It's there's been a big debate about whether the 20% safe harbor is something that is useful or not. I don't want to take too much time on this panel to discuss. I tend to think not, but I do think the guidelines are a good idea. I think the question is just exactly how they're going to be applied and what is behind some of the theories of harm that are stated out there in a relatively short document that over time, and we'll see how the agencies end up applying them over the next several months, I would say.
Great. Thank you. And several things there that I think we'll hopefully have time to unpack a little bit more in terms of the privacy versus competition balance. But before we get into that, we've established this topic of vertically integrated digital platforms has been hot and has been spreading. But right now we're dealing with a much more viral COVID-19 pandemic. So I think we should spend a bit of time addressing issues that are being raised given that current situation. So there are suggestions, given this current situation, that it will trigger a big coronavirus monopoly roll-up with digital platforms leading the way in a major shopping spree. And Cristina, I think as you pointed out, The Economist wrote last week that just as the big firms are standing ever taller, many of the tech industry's younger, smaller firms are being crushed in the worst slump since the dot-com crash. Collapsing firms could be snapped up by the tech giants, and regulators will do little or nothing to stop a round of consolidations. So I'll open it up to the group, but I'll direct it to Cristina first. Is this a prediction we need to worry about?
Well, by the way, in the way of background, briefly, we know what motivates this concern is a broader issue, which has been around for some time. We know that the way in which tech rules, if you like, has been traditionally to scour the landscape, identify sort of startups, nascent businesses that are complementary, that are interesting, and integrate them into their platform, in ways that certainly provides them with capabilities, with funding, with way out. Liquidity event, if you want to call them that way, to entrepreneurs, and that is the way in which things have been progressing. The narrative more recently has been very much around, well, we've been witnessing hundreds of these events in the past few years. We have actually looked at very few of them, are concerned that by doing so we have missed out. We missed out on effectively catching early some of these consolidations that could be significant in competition terms for the future. Now, I don't particularly like the abuse of the terminology killer acquisition in tech space, because that is something which has got a role in pharma. It comes out of that, where you can identify these events quite precisely. I don't think that there are that many situations in which you are looking at a tech company deliberately buying a future replacement, which would be a more kind of precise definition of killer. But there is no question that we're looking at a wide variety of motivation for some of these deals. Some are really intended to put together complements in ways that are benign. Some others are potentially less so, and we need to interrogate ourselves about what are the effects of these deals potentially to future potential entry. Are we allowing something that eliminates, by definition, potential future entry, that undermines future potential competition by taking out the potential entry into a sector? So I mean, all of this is the background against which this discussion is taking place. And the article you were mentioning in The Economist is essentially saying, against this, given the effect of COVID, which is very much uncertain yet at this stage, but there is a big question about the extent to which VC and private equity are going to continue to maintain the level of funding that they have provided so far for these nascent plays. Are we going to see a decimation of these plays? And are we in a situation in which the agencies, like in the past, that this is I'm channeling, have not really been able or willing to catch enough of these deals in a way that has meant we have actually foregone important competition in these spaces? So I think there are multiple questions. It's not clear the extent to which, in fact, the funding environment is going to be that badly affected. My information at this stage, but it remains to be seen how long things things last, is that there is still quite a lot of money looking for a home in VCs and private equity. In fact, there are some that are actually seeking to indeed proactively invest in situations in which asset prices are quite low. So will we see more of these acquisitions? Possibly. I see some indications that acquisitions are being planned. I, at the same time, disagree with the notion that this is going to be something that the agencies will let happen. Why should that be? I think the debate in the last few years has been, I think, a big wake-up call generally, but I think agencies have become very sensitized to this kind of issues. I speak particularly, given where I am, for the UK CMA. The UK CMA is a leading agency which has become very focused on digital, on potential competition, is a major theory of harm, is pursuing a number of cases in this space. I cannot imagine that even in the gravity of the current situation, this will not be continuing to be an area of focus. In fact, I know that resources are actually being diverted to mergers and to really catch up and catch these kind of things. So I think that it is possible we will see a major increase in attempted acquisition or acqui-hires, if you want to call it that way, which is no different. But I'm more optimistic about the fact that agencies are not going to let these things through just because we're in a crisis. I think that there will be significant scrutiny on this because people are aware that this is an issue that's been talked about.
So there have actually been suggestions made that by various different groups that all mergers or mergers by large companies should be prohibited during the pandemic because the agencies don't have the resources right now to deal with these complex issues for various reasons, including the challenges of working from home, diverted focus, and so forth. In the US, the Pre-Merger Notification Office quickly resumed processing early termination requests, and DOJ promised quick reviews of collaborations related to COVID efforts, which also suggests that the agencies have very quickly pivoted and are capable. Commissioner Phillips, what is your perspective on both this issue of do we need to be more concerned about coronavirus monopoly roll-ups and the ability of the agencies to respond at this time?
Thanks, Gabrielle. Let me take the questions in reverse order. The first with respect to the agency's capability under the circumstances of a pandemic. Certainly, there are functions that in a situation like this where a lot of work is being done remotely have to change and capacity may be somewhat reduced. But as you noted, as a practical matter, P&O is up and running. We've reintroduced early termination. Our staff are terrific. People are resilient, and they're finding ways to work through this. So that's the first issue. The second thing I'd note is that, at least so far, what we're seeing now, which is exactly what you would expect in a market situation like this, is a downward trend in filings, right? Stock prices are lower, companies are burning through cash reserves, the ability to access equity and debt markets is less than it was, and so you're seeing a downward trend, generally speaking, in acquisition, which means that with respect to how the agencies are functioning, to some extent, at least in terms of the numbers that we're seeing, what the data show is that the burden has been lessened because there's less M&A going on. Now, to pivot to this question of small acquisitions, I think one important thing to note, which Cristina touched upon, is that this has been a big question long before the COVID-19 pandemic. And it is in fact such a question that, at least in the tech space, you saw us putting out our 6B study for 5 of the large tech companies to look at some of their smaller acquisitions, the stuff that doesn't get noticed to us. We do review routinely acquisitions that don't get noticed to us under HSR. And you see some tech acquisitions today that get reported even though they're not reportable to us under HSR. But the notion that that nascent competition and squelching that out may be a concern, the term killer acquisition in the pharma space, the notion that these are areas of concern for the agencies in the US and abroad is not new. And I don't think that's going to change. I think people are continuing to apply scrutiny. In terms of what coronavirus changes, with all due respect to the editorial choices of The Economist, which was quoted earlier, it's not clear to me how much that's a tech issue. If you see massive business failures across the economy, which everyone is concerned about, to the extent there are remaining some firms that are better resourced, you might expect to see some M&A activity. Even if the broader trends on M&A were down, you certainly might see certain firms picking up. And we would look at those acquisitions, I think, the same way we looked at other acquisitions. So I don't know that that is a tech-specific issue. There is a lot of hiring going on right now by the bigger firms in Silicon Valley, but I don't begrudge people who've lost their job at the company that's going and getting jobs elsewhere. That's not necessarily the same thing as M&A. In general, I think we take the context into account. You will see, I'm sure, more failing firm defenses getting made. But that's a pretty, as Craig, I'm sure, can speak to as well, that's a pretty hard test to meet. The failing firm defense is not something that is easy to prove. And we're always skeptical of claims that folks make. I'd expect to see more of those because there are a lot more failing firms, and that's not a surprising thing. The one sort of final point I'd make is that I've never viewed antitrust as a mechanism for industrial planning. And as a means to try to prop up firms, whether you're talking about, going after firms because other firms want you to go after them, or you're talking about letting antitrust not operate or go fallow in order to protect, let's say, national champions. To me, antitrust is about protecting competition. So, of course, we're going to take into account the competitive realities looking at a transaction. But just because there's been a change in circumstances, even if there are other equities at issue, it's not clear to me that antitrust is always the way of getting those. So I probably have been talking for too long, so I'll leave it to others at this point.
Yeah.
Gabrielle, do you mind if I jump? Gabrielle, is it possible if I ask you to Commissioner Phillips said? Sorry to interrupt. Yeah, I'm going back to your first proposition that the notion that we wouldn't be overseeing antitrust because of the pandemic. I mean, I personally don't think that's giving enough credit to the agencies. I mean, my experience was when these all became our remote homes, our remote offices, that everybody adjusted, that life became working from home. The agencies did it very quickly. We didn't have many, if any, meetings canceled with them. And so this is the new normal that we're all adjusting to. We don't know how long it's going to be going on. And the agencies are fully capable of overseeing the transactions that come before them. To Commissioner Phillips' point, there should be less of them because of the HSR filings going down. So that's sort of point one. And point two, I certainly agree with Commissioner Phillips. You will see more, whether it's a failing firm or a flailing firm or reverse General Dynamics, call it what you want. There are going to be more companies coming forward and saying that these are issues. Some will be credible, some will be challenged, some will be, they'll fall into various buckets. But yeah, I think certainly just by the nature of the fact that the world's a different place right now, I would imagine that there will be more, and you'll have to prove your points. I mean, you'll have to prove your case, and obviously the agency will be on the lookout for that.
Right.
Can I make a very brief jumping comment before Thomas? Sorry to just jump in before you, Thomas. Just in response to Commissioner Phillips' legitimate question, which is, what does COVID change in all of this? I think just to go to that point, probably nothing fundamentally, but I think the article on The Economist was trying to make the point that in the current crisis, the resilience of the large platform is huge, and they will come out, as the economists say, standing taller, there's no question. And whereas there will be, of course, a decimation of smaller player, and so inevitably we will see an incentive to acquire. And so there will be even more concentration there to the extent that we worry about that. I don't think this is specific to the digital sector, of course. There is possibly going to be a very significant increase in concentration more broadly, but that is very much, I think, a safe prediction for the tech sector, in which you have the major giants effectively being so resilient. And the other sort of dimension of it, which is more subtle, and it is what gets a bit unspoken in this situation, is that there is a bit of a sense on the part of the platforms themselves, and I talk to them, that we are doing so much in the current environment. We are doing so much, governments are asking so much of us, they are relying on us to do essential things. They should give us a little bit of slack when it comes to doing deals. And it may surprise, because of course, to practitioners, the notion that there can be a quid pro quo between different parts of government is alien, but there is a sentiment that there is some sort of IOU which is being somehow obtained, a credit, which should justify perhaps a more lenient approach to some of these. I've heard it directly. So I think that is possibly what is in the background.
So Thomas, finally, I want to give you,
After Thomas.
Okay. I want to give Thomas a chance to comment if there's anything else, but also because you raised the point of, antitrust is not top of mind as we're dealing with a lot of these bigger issues, but we do have a lot of investigations that are currently in process, and including market reviews in the UK, investigations that are going on in the EU. And so I guess one question is, are these still priorities of any type of degree? Or is the way that, as Cristina raised it, the fact that the companies may be helping with the COVID response, pushing out timelines or leading to a reallocation of priorities or resources towards other issues of interest for right now?
So very first on, is anything going to change after COVID, especially with regard to big tech? Big tech itself seems to think that nothing will change. I think Eric Schmidt gave an interview in Fortune last week where he said, if anything, big tech will come out stronger after this crisis because they have the cash and they have the brands, which makes it more difficult for others basically to compete. So that's the assumption that they seem to be departing from. Does it change anything in terms of investigations that are ongoing? For us on the Commission side, obviously there are other more urgent priorities now that one has to admit. We just issued, after I think 17 years, the first comfort letter to a company after 17 years in pharmaceuticals in order to ensure security of supply of pharmaceutical products. That's probably a bit more urgent, I would think, than looking into big platform markets now. But I don't think it will be at on the back burner, the platform investigations. They will also go on. They will probably take a bit longer, as other more urgent pressing things are on the agenda now, especially when it comes to supply constraints, also ensuring security of supply. But I don't think that we'll now turn a blind eye on platforms. To the contrary, I think when things get a bit more back to normal, these investigations will certainly resume and to take a very close look at these platform markets as well.
Commissioner Phillips.
Sure, I just want to respond to one thing Cristina said, and that is in terms of the notion that certain companies, because they're viewed in a better light, are going to get a pass on things they otherwise wouldn't have. My view is that if you're targeting your antitrust enforcement based on the general popularity of a company, whether it's in the good graces for reasons that are exogenous to antitrust law, you probably shouldn't be in the business of antitrust enforcement. Just like the fact that a lot of people might not like a company isn't a good reason to target them before the crisis, the fact that they're behaving well in some other context shouldn't inoculate them from antitrust review. We're not popularity police, we're supposed to be policing competition. I think Thomas is certainly correct that in the context of a crisis, there are certain things that will rise to more immediate and expedited treatment. You see the DOJ and the FTC making our announcement with respect to quick review of collaborations that may be needed under these circumstances. But, you know, like Mitch McConnell often says, we can walk and chew gum. And so while dealing with a bunch of things, I don't see like a massive pivot in terms of enforcement.
All right. Well, turning back to this issue that was raised previously in terms of, as we're looking at these things, how do we balance competition and privacy? Are they part of the same package, or are they two separate things? And we are balancing. One of the central concerns around vertically integrated digital platforms is data. And the biggest concern right now, especially in light of COVID, is how do we balance data use, data protection, privacy against other important policy goals like competition, or as others have pointed out, things like public health. So the debate surrounding how this balance should play out has really only heated up in light of COVID-19 and initiatives undertaken by the vertically digital, integrated digital platforms. The initiative that Apple and Google announced on April 10th to create a contact tracing technology is a prime example. So again, turning to you, Commissioner Phillips, particularly given your experience with both privacy and competition issues at the FTC, how do you think about that balance of privacy and competition?
Thanks, Gabrielle. So I gave a speech a few months ago called "Should We Block This Merger?" about the integration or the proposed integration of privacy and antitrust. And I kind of end up where Craig ends up, and that is these are two different things. Data, some of which can implicate privacy because it can be like consumer data or health data about people, has been a factor in antitrust review and continues to be a matter of tremendous introspection and study about how we approach data issues in the context of competition. You see it reflected in how we deal with remedies, firewalls on the one hand, interoperability on the other. I think issues about data are something we're continuing to look at and we're going to continue to be interested in. With respect to privacy, you know, it is possible that you could think of privacy as an aspect of quality. And to the extent market dynamics are bearing on it, and you saw some transaction where the lessening of that could be a competitive harm. But the circumstances under which you're going to see that happen, I think, are more rare than a lot of people are recognizing. And that's so in part because privacy is a much more difficult thing to talk about than, say, price. Your experience with something as pro or negative on privacy may be different from mine. And you don't see preference for privacy revealed in the same way that you do for lower price. Everybody wants lower prices, but you know, your creepy reach out by the ad company for the coupon as you walk by Starbucks may be my positive experience. Isn't that great? That's just when I needed the coupon. And that makes privacy a little more difficult. I get very nervous, and that's part of why I gave the speech that I did in this conversation, because while, again, privacy can be considered an aspect of quality, there are a lot of things that can. And I worry that some of the reason that privacy is rising as a particular point of emphasis is not because it presents sort of different competition issues than any other area of quality, but rather because it impacts the same number of firms. And what I don't think we should be doing is developing new doctrine around the targets, as opposed to be thinking about what the doctrine captures and what it doesn't. And I'll add one important thing. Privacy and competition can sometimes be at odds, not always, but sometimes. So if you think about our privacy enforcement against Facebook, where Facebook was allowing through its Graph API access to lots of data from people to app developers. That was bad for privacy, and a lot of people got very angry, and rightly so, at Facebook for its conduct. But it arguably was pro-competitive in that it was allowing access to data for thousands and thousands of firms. In fact, when we came out with our settlement with Facebook, Alex Stamos, who's a pretty smart person on these issues, complained that we were correcting in the wrong direction because now this important resource, this access to data about all these people, would be cut off to all these future competitors. And I think there's a lot to that. And I think people need to be pretty careful about assuming that privacy and antitrust in every case are going to move in the same direction. They may, but in many cases, they can move in opposite directions.
Thomas, Cristina, Craig, do you want to respond? Do you have any different views, or you agree? I think, Craig, you kind of already foreshadowed that you were along the same line. So Cristina and Thomas, I don't know if you
want
agree
to go
or view
first?
this differently.
Yeah, sure. No, I'd rather echo what Commissioner Phillips just said. I think one needs to be careful in putting privacy and antitrust enforcement into the same box. I mean, fundamentally, at least in Europe, they have two different goals, and these two different goals you have to keep in mind. I mean, privacy, or data protection as we call it, is a fundamental right. It protects the individual here, at least. We have the GDPR, which is very clear about that. And antitrust law, as we see it in Europe, is about the protection of the competitive process. So it's two different things. But that doesn't mean that the two cannot work hand in hand. And there cannot be links between the two. But one has to link it properly, you know, and the German Facebook case is a very good example. The German antitrust authority took issue with Facebook basically gathering the data from Instagram, WhatsApp, and the like buttons all together, which they shouldn't have been doing under the GDPR, so under data protection rules. But the German Competition Authority also deemed that to be an antitrust infringement. And the discussion, I think rightly so, in Germany now and also in the rest of Europe is what does one have to show in order to make the link between this infringement of data protection rules, if you want, and antitrust. And the link is, I think, does it affect competition, and how does it affect competition? So you have to go a step further than just saying there's a violation of privacy rules, probably, and you cannot equate any. Well, that would be too simple, I would think, and to equate any violation of privacy rules with a violation of antitrust rules. You'd have to go further and investigate what this violation of privacy rules, in this specific case, the gathering or the pooling of the data, what that means for competition. Does it strengthen Facebook's market power? What does it mean for competitors? Do they have a harder time because Facebook has this data advantage? So I think there can be links, definitely, but one shouldn't put everything into one box, given the different goals of the two rules. And in Europe, obviously, we have the advantage that we are more used to unfair trading practices also being considered as an antitrust infringement. So we have the exploitative angle that we can use, and I think I wouldn't exclude that exploitative abuses become more of a mainstream when we talk about privacy and data. So that's where we are on this.
Very much agree with Thomas. I think that the distinction between privacy and antitrust is not something I'm too happy with, because I think fundamentally privacy is also a competition issue in the following sense. If we had more competition, we'd have more privacy, and we have better privacy standard. It is actually a reflection of the fact that competition is dwindled to almost nothing in some of these areas, that privacy is as low standard as it is. Now, that said, I do agree that it is not easy to pursue privacy goals through competition, nor necessarily appropriate. Although, like Thomas, or perhaps not like you, but personally, I'm very fond of the German Facebook decision. I think it's a great case in which the German cartel office has shown imagination. The case has been, of course, appealed. It has failed on appeal, but I think that the cartel office should keep going and try it out, do it better. But I very much like the notion that we are able to make a little bit more imaginative claims around around the accumulation of data in ways that are concerning us and linking it to market power, because that market power depends on the data fire hose that these companies are able to create, and there are concerns about this data accumulation being done in ways that preserve the privacy in ways we want. So that said, I think, as I mentioned, it is I think inadequate to expect that we can pursue privacy goals through competition enforcement. Privacy goals need to be pursued through the complementary route of regulation. We are not going to actually make progress on the kind of things that we need to ensure competition, like interoperability, like data pooling, data sharing, that are at the core of the European project on data, if we don't properly regulate what that means. And so that is something that cannot be done by an antitrust authority to an antitrust case. It is something in which a regulator needs to come in. And so there are questions about what that kind of regulation will be. But there's no question that that is what's coming down the pipes over here.
Thank you, Cristina. So I think we could go on for several more hours, but as our time is running short, I want to thank all of you for joining, and hope that you all stay healthy and as lively as this debate has been until we get to an end of social distancing and can be together again. Thank you all.
Thank you.
All right, great. Thank you, Gabrielle. And we are back with our two experts, Matthew Kent and Eli Katz. Matthew, let's start with you. What are some of the takeaways from today's panel?
Well, one of the interesting things, and I think Cristina really hit on this, is that the economic tools are really not very well developed for trying to assess and understand the competitive effects that vertical integration for digital platforms can have. And I think that's critical because it'll be interesting to see how economists and how the agencies and how we even counsel our individual clients about assessing the impacts through an empirical method. And I thought another really very practical point that Craig made was that when you don't have those empirical devices and that assessment, it really becomes important to understand the facts, because those are going to drive the results in a particular case. And I don't think any of the panelists mentioned intent, but it'll be interesting to see how ordinary course business documents are used to sort of review and infer intent.
Eli, what about you?
Great points, Matthew. I really, I think you hit on important points. I want to sort of add another thing that I found very interesting is that even though there was, some differences in views on these issues, everyone seemed to agree that specific facts matter. You need to understand the business models, and they're not all the same. You need to understand the specific vertical relationships, and that's so important both in enforcement and in counseling. Another thing I thought that I noticed that was interesting and important, I'm glad that they had spent some time on, is the impact of the pandemic. And I think what I got from what I heard was that the pandemic may impact the type of deals we see. We don't know yet. We heard that there is a slowdown in HSR filings, but we also heard that there may be some particular kind of deals, opportunistic deals out there. But what I think I understood is that the review may be quicker. There may be different types of deals, but the robustness of enforcement is not expected to change. And I found all that to be very interesting. And lastly, I was interested in how the discussion went on to privacy versus competition, and really zeroing in, where is privacy a competitive issue and where it isn't. That's not easy, but I have to congratulate the panel for tackling all those issues in an engaging and really informative way.
Yeah, it's interesting, Eli, because I think on the privacy front, it was interesting to hear about both the EU enforcer perspective and the US enforcer perspective, and them agreeing that antitrust and privacy should be looked at separately. And then, of course, Cristina coming in and thinking about it more from the economic framework and analyzing that as a question of whether or not there's actually competition in the space, and thinking about there being more privacy if there is more competition, which I thought was an interesting framework, although I'm not sure that always necessarily holds, because consumer preferences on privacy are so different here in the U.S. and perhaps culturally there are some differences that we're observing on that. But certainly interesting to get into the privacy regime, because anytime we're talking about digital platforms, many of which we're going to touch every single day, those are going to be critical issues that drive network effects.
Eli, any final thoughts?
No, I agree with the observation that Matthew just made about there are differences across the pond, but there are similarities, and we're really still figuring out. And I think it's changing. You know, not only is it different from culture to culture, but over time, our view and understanding of what does privacy mean to us, and what does it mean in a competitive space. We as a species have known for a long time what we understand price to be in a competitive space, but privacy is new, and I think that was brought out nicely. So again, it was a really great panel.
Eli, let's stick with you, and I want to shift gears just a little bit. You're the chair of the Corporate Counseling Committee. Can you tell us a little bit about what the committee is up to, how benefits it may be offering for members, and maybe how folks can get involved?
Sure. I'd be very happy to. So we do lots of great programs and content that's geared specifically for in-house counsel, but not exclusively for in-house counsel. A lot of other lawyers, both enforcers, private practitioners, academics join our programs as well. But the most popular one I want to talk about is our monthly antitrust update. It's a great way, whether you're one of those people who reads daily about what's coming out in the antitrust world, or you're someone who's got to focus on other things and you can only get to focus on antitrust developments every once in a while, this is a way to really catch up on a monthly basis on what's important and hear some helpful analysis that is geared specifically towards what in-house lawyers might be interested in. And, you know, as always, we're eager to have young lawyers get involved, and anyone who wants to participate, listen to the update, join, please just email me at ecats@khill.com, and I'll be happy to connect you with the right people and get you involved.
Awesome. Matthew, same question for you, but different committee. You're the chair of the Unilateral Conduct Committee. What are you up to? How can people get involved?
Absolutely. Well, thanks, John. So I'm actually co-chair with Eleanor Hoffman, who's at the New York State Attorney General's office and is always working on antitrust and consumer protection issues. We have so much going on our committee. Right now, we're working on 2 publications, a standard-setting organization handbook, as well as a monopolization and dominance handbook. We also, we're about to publish our second newsletter, Monopoly Matters. It's sort of an exciting time to be with the committee, because after the virtual spring meeting is over, our regular programming begins again. And so we have a slate of 4 programs to end the antitrust section year strong. And so we're really excited about all of that content, because on this committee, and I also applaud Eli's committee, those corporate counseling updates are fantastic, but we want to be the thought leaders in this area. And so when we think about programming, it's really a great place for our young lawyers to get involved. They can either speak on the programs, or they can team up with someone who is an expert in the area. And that has been a really productive way for our young lawyer members to both get involved, to find informal mentorship opportunities, and really get a deep understanding of this area. And we also, of course, have the publications. We're always happy for more laboring oars, and our young lawyers have been able to contribute meaningful articles for our newsletter, as well as chapters for our books that we're publishing.
And Eli, I think I was probably remiss in not mentioning you also have a co-chair.
Yes,
for your
I'm a co-chair. I wanted to add that, and I'm a co-chair with Peggy Ward, and the work that she has been doing is great on our committee. What I wanted to add, the Unilateral Conduct Committee does great things, and this is an example where you can see, you know, not only competition amongst committees, but also collaboration, which is the way I think it should be.
Fully agree. And you know, the topic today was very important, very interesting, and I think it's fairly fast moving. So Eli, Matthew, hopefully you will come back and join us on the Arcurious Amalgam podcast or in other programs, and we can watch this space. Let's continue to explore it together. Would you guys be willing to do that?
Definitely.
Absolutely. Thanks, John.
All right. Well,
thanks for having us.
Well, thank you. And Matthew and Eli, thank you for the great commentary, the great context, helping us to understand how things worked a little bit better today. Also want to thank Gabrielle KOHLMEIER, all the panelists today. Worked really, really hard to put this together, and it paid. Really wonderful panel. Most importantly, I want to thank folks who are watching. Thank you. We really appreciate your checking us out. And until we speak again, please be well and be safe.